Property owners don't shovel, or they don't plow, or they don't put down salt. And that opens up, liability. Those injuries, those events fuel phone calls to my office and other lawyers' offices. This is the very thing. This is the very stuff that I'm trying to talk about, which can at least help you perhaps mitigate or manage any potential exposure to this. But I recognize even best efforts sometimes can fall short. So as someone who's watching this video with an eye toward maybe trying to insulate themselves, be prudent, be diligent, but you don't have to be heroic either, right? If you just use your eyes, use your ears, use your senses, you'll be able to spot some of these things fairly easily and take care of them fairly easily. So when I represent someone who gets hurt in these types of cases, I will often ask them at a deposition, or perhaps before that, ask the lawyers to produce paper showing, well, what kind of effort is invested by the owner to inspect and examine and just look over their property after these things happen. And some of these events can be, sometimes we're measuring snow in feet, not just inches. Where does it all go? Does it get piled up in a corner? And when it starts to warm up, start to melt, what happens in those situations, right? So we've talked about actual notice and constructive notice. Now there could be situations where liability can open up to a landowner for causing or creating the very defect which someone got hurt on in the first place. So that example I just said is a common one, right? People plow their snow and ice, or they pile it up in the same place. And as time goes on, there can be some thawing days or some warm-ups, or maybe it's a late season snowfall into early spring, and the snowfall's followed by a very warm day or two where there's a lot of melting, but maybe at night it refreezes, right? The recurring condition can also be something that exposes a landowner to liability. So that stuff, I think, makes a lot of sense too, right? It kind of falls into the same type of logic that I just detailed. You might be great at clearing off your driveway or your parking lot and your sidewalks. You might be thorough and diligent and timely, and you put your salt down and you put your sand down, whatever you need to do to keep the surface gritty and afford traction to pedestrians. But maybe you pile it up somewhere in a place where when that melting begins and the runoff begins, that it just kind of leads itself right back into the path where people are routinely walking, like say in a crosswalk or in a popular spot of a parking lot. You got to manage that. You have to be thoughtful as a property owner in all respects. And I know some of you might be thinking, well, geez, there's only so much you can do. Maybe you'll have so much space. Maybe there's only, there's limits to what you can do. And I recognize that. I do. But when I'm representing the accident victim, my concern is for their welfare and their well-being. And if someone breaks their leg and has hardware put into their body, and I've had plenty of those cases, quite frankly, I'm not going to be as interested or invested into what the homeowner or the property owner did. More likely I'll be focusing on what they didn't do and what they should have done. So while I can see both sides, my job and my loyalty, of course, is going to be to my clients and the injury victims themselves. So if we can prove that a landowner knew about something that recurred time and again, and they did it anyways, well, that's just going to fuel our fire. That's just going to fuel our ability, I believe, to confidently prove and succeed in proving that they are responsible for causing and creating the very defect and condition which led to my client's injuries.